Hello, and welcome to PubK's 2022 Government Contracts Annual Review. We're thrilled to have more than 3,000 session registrants for the entire program. Over today and the next 2 afternoons, we'll present 8 additional sessions. We hope you'll be able to join us for most, if not all, of these sessions, but a separate registration is required for each session that you want to attend, which you can still register for at the PubK website under the Annual Review tab. My name is Alan Schwantken. I'm the president of the PubK Group and a partner in the law firm Nichols Lew. I'll be your host, facilitator, moderator, and maybe even an occasional agitator for this year's annual review. Let's hope we can convene in person next year. The PubK Group consists of 3 newsletters: PubK Law, PubK Compliance, and PubK Cyber. Many of you are already subscribers to one or more of these publications, and we very much appreciate your support. Some of you who are joining this review are not yet subscribers. I hope you'll consider becoming a subscriber soon. Information is at the website shown on the slide or is available from any of the contacts you have here at the PubK Group. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on these next 2 slides. I want to thank them for their support and encourage you to look at the skills and capabilities that these firms have. In lieu of speaker gifts and in honor of our sponsors, PubK is making a contribution to the Capital Area Food Bank. With the food crisis facing our communities, including the military, and here in the Washington, D.C. metropolitan area, I hope you'll consider making an individual or an organizational contribution. Since the entire program is being held virtually, all attendees will be in listen-only mode, and your video will remain disabled throughout the session. However, we do welcome your questions. Use the Q&A box at the bottom of your screen. However, with so many attendees, it's probably not possible to answer all of the questions in real time. We are capturing your questions and will endeavor to get as many answers as possible after the conclusion of the annual review. All presentation slides, along with the audio, will be available for download from the PubK website, probably within a week or so of the conclusion of the annual review. We'll send out an email to you when this information is available for download, how to access it, and for how long the material will be available. You can also follow us on LinkedIn and bookmark our YouTube channel. We'll be posting information on those platforms as well. We're also applying for continuing legal education in a number of jurisdictions. While we can't guarantee approval of the CLE credits, we expect that acceptance within the next few weeks. Again, we'll notify all attendees when those approvals have been received. But if you're interested in obtaining CLE, please look for our poll question during the presentation. The state boards require us to verify your participation during the event. The poll is a simple yes/no question. We'll keep track of the responses to verify that you viewed the panel. If you do not wish to obtain CLE credit, you can disregard the poll or just answer for fun. Now, I'm thrilled to kick off day 2 of the 7th annual PubK annual review with our session 4 panel on cost, pricing, and audits. Our distinguished panel members are Joe McCaffrey from Baker Tilly, Greg Bingham from HKA, Paul Pompeo from Arnold and Porter, and Ryan Bird from Berkeley Research Group. Ryan, over to you.
Thank you, Alan, for the introductions. Today's panel will review developments involving contract costs, pricing, and audits, and we hope to simplify some of these complex rules and regulations as well as case law. Joe's going to start us off today with a review of audit issues, focusing on trends and areas of emphasis from DCA and other audit agencies, the proposed DFARS rule regarding incurred IR&D costs, and other applicable legal cases. Paul will lead a conversation in cost allowability developments and related legal cases, primarily focused on Raytheon and Northrop Grumman. Greg will lead us today through the conversation related to TINA and pricing developments with trends in defective pricing, as well as the TransDigm saga that continues. We'll discuss the COVID-related funding and guidance from DCA related to incurred cost submissions and applicable credits, as well as forward pricing considerations. And we'll finish today's session with cost accounting standards and the limited updates that exist within that area. Joe, I'll turn it over to you to lead the conversation regarding audit issues.
Thanks, Ryan. And you can advance to the next slide. So we'll start off by discussing, what DCAA has been focusing on in the past year and what we've seen. And as usual, DCAA published its report to Congress late last spring, and that covers the government fiscal year 20 audit activity for DCAA. The report's generally the same format as prior years, focusing on what DCAA's initiatives are, the number of audit reports that they've issued, the number of net savings, and the sustention rates across the audit reports that they've issued. So it's the same format as prior years, and so it's the same challenges of discerning some of the numbers and how they make sense and how they relate to each other. Sustention rates, there's generally consistent now year over year from FY19 to FY20. There was a little blip on the sustention rate for business system, TINA, and CAS audits. But otherwise, the report is useful to see where DCA is actually spending their time and their effort. They did clarify that they used third-party auditors to conduct about 100 incurred cost audits, and we'll talk a little bit more about that in a few minutes. But what's shown on the screen now is the trend year over year of the number of audit reports issued and the amount of time, or essentially dollars, that DCA itself is spending on conducting those audits. And so on the right-hand side of the screen, you can really see that DCAA has shifted its focus and is increasing the number of business system, TINA, and CAS audits that it's conducting and issuing audit reports for, and the amount of time that it's spending on that. And the number of audit reports and effort on incurred cost submissions is dropping. And that's generally due to DCA being up to date on their incurred cost backlog. So related to the business system and TINA issue, the report also has an interesting blip in it. The report does summarize the number of, or the amount of dollars that are subject to those audits. And in 2019's audit report, the audit coverage for that area was reported to be about $35 million across those 299 audit reports that were issued. In the 2020 report, it's saying that across the 437 reports issued, that approximately $30 billion was covered. So again, it's another area where, without being able to see the details behind how DCA is compiling their numbers here, it's a little difficult to discern what they're actually reporting on and whether there was a change in methodology there. So other folks on the panel, I'm not sure if there's any other specifics on the DCAA report itself, but if not, we may talk a little bit about trends on the business system audits itself that we're seeing, if you want to go to the next slide.
Well, and before we move on, I'll just comment about the trends in claims and terminations. And this, I think, is reflected some in the 2021 activity, and I think it will be reflected in the 2022 activity. And that is, with the Taliban takeover in Afghanistan, there are a lot of contracts with claims and or terminations for contractors there. And so that's driving a fair amount of activity for the DCAA. A lot of Army Corps of Engineers, but not exclusively Army Corps of Engineers contracts. And then my practice, I certainly am seeing a lot more TINA activity and defective pricing, post-award audits, that sort of thing. And the data that Joe just walked through is certainly consistent with that. That's the only comment I had, Joe.
And again, this report covers government fiscal year 20, so ended September 2020. We'll hopefully soon get a report covering government fiscal year 21, which would only take us to right around the starting point of some of the turmoil in Afghanistan, Greg. So agree, it'll be interesting to see how that affects the numbers in the upcoming years.
In addition to Afghanistan, we're seeing an uptick regarding border wall terminations. So as that funding stream works its way out, I think we'll continue to see some additional claims or REAs and terminations in that area as well.
That's a good point, Ryan. I'd forgotten to mention that as well. And those are very, I don't think there's a whole lot of those, but they're very high profile, and DCA is probably spending a lot of time on them because of the complicated nature.
Yeah, so if you want to advance to the next slide. So DCAA a few years ago was held to account by DODIG for falling behind on business system audits, and DCAA made a pledge in their plan to do more business system audits. And what we've generally seen now, experience with clients, is more audits being kicked off, conducted, and reports being issued. And that's also being shown in the report itself now from DCAA. But across those business system audits, there's some recurring trends and challenges that contractors and DCAA are having in conducting and getting those audits done. In some of the information that DCAA has been providing in other briefings, in 2020, they issued about 270 audit reports on business systems alone. And in 2021, they issued about 336 business systems. So a good increase there, but it's not clear whether that's full system audits, whether they're auditing one specific area or corrective action, or whether those include things like pre-award 1408 accounting system reviews, which are also a little bit of a lighter touch compared to the full DFARS business system reviews. But what I've seen with clients in business system audits, and would be curious to hear from Ryan and Greg and Paul as well, is a few consistent things. So just like contractors haven't had business system audits in a few years, and they need muscle memory to go through to be able to manage those audits and make sure they have the right internal controls and processes in place to pass an audit. DCAA themselves hasn't conducted a lot of these. And so contractors are finding that they're having to provide a lot more handholding and training to auditors in certain areas, especially around estimating system audits, where a lot of DCAA auditors have not had a lot of experience in the past. Another thing I've seen is old audit issues from whether they were incurred cost audit findings or outstanding CAS issues or other areas, finding their way into business system audits as well, whether those are being flagged as significant deficiencies or something other than significant deficiencies as well. And then that kind of ties into the last point, that there's not still a clear agreement on what actually constitutes a significant deficiency and what should rise to that level. And inconsistencies even at one contractor from audit to audit, or across clients and contractors as well. So I'm not sure if Ryan or Greg or Paul, those ring true for you, or you're seeing anything different in those areas.
I'll just comment. What you said is consistent with my experience. You probably are seeing more of it than I am, but it's consistent with what I'm seeing. The estimating, certainly a lot of emphasis in the estimating systems area, and lack of knowledge, if you will, just because I think it's been years since there was such a focus on as intense a focus as there is now on estimating. With regard to the use of the third-party auditors, the comment occurred to me, be careful what you wish for. I mean, I think 10 years ago, people were thinking, oh, if we could get some auditor other than DCAA, how wonderful that would be. And now we have some that are not as, maybe not as educated on government contract cost accounting issues as the DCAA. And so that can be a challenge, of course, for contractors dealing with audits.
Ryan, were you gonna jump in?
Yeah, our experience is similar to both Joe, yours, and Greg's experience. I mean, there's typically, from year to year, if you even have consistent third-party auditors coming in, their understanding of certain technical areas could be lacking, so there's education involved. I think from a business system perspective, audit, you never can over prepare for a business system audit or walkthroughs. And I think that's kind of the lesson learned. Any amount of preparation, pulling documentations, preparing for walkthroughs, helping the auditors understand the system so they don't go down rabbit holes and explore areas that are not relevant, potentially finding other issues is critical to ensure the success of a business system audit. But we're definitely seeing inconsistency from year to year, especially when some of the agencies, even civilian agencies, are using different auditors for the same contractor year over year.
And tying into third-party auditors, Greg, agreed, be careful what you wish for. I think what we've seen, or maybe haven't seen, like I haven't seen a lot of questions or concerns about third-party auditors that DCAA has been using. Seems like they're generally using those on lower risk auditors audits or companies in DCAA's opinion. But what you're saying, what you're both saying around civilian agency usage of third-party auditors, whether that's USAID or DOE, HHS or others, that definitely rings true. Not all of those auditors are fully immersed in the world of the FAR and DFARs and cost accounting standards and business system audits. And so it's crucially important in those instances also, we found, to engage with the contracting officer early to make sure, scope of the audit is appropriate for what the contracting officer is looking for, make sure that the auditors understand that as well, to help resolve some of the issues up front potentially as well. Because we're seeing their use not only on incurred cost audits, but disclosure statement, adequacy reviews or audits, and business system issues as well.
And I'll just comment about the MMAS, Material Management and Accounting System. I can remember when that came out in the late 1980s, I believe it was, the 10 key elements of material management and accounting system. And that was there was a surge of activity related to that. And I get why at that point, you think about what the Department of Defense was buying then, it was much more heavy manufacturing oriented. Today, there is still heavy manufacturing, but the emphasis has shifted somewhat to services and other things other than heavy manufacturing. So I'm a little surprised to see an emphasis on material management, inventory management, that sort of thing. My take is that the emphasis on MMAS got too low, and now it's rebounding, is my take.
And I think most of the audit activity that I've seen is around accounting and estimating systems as primary focus. But agree, if you have the material management accounting system clause in your contract, be aware, make sure it's appropriately included if it should be there. If it shouldn't, talk to your contracting officer again, because you don't want to subject yourself to an audit that you may not need if DCA comes in. And then the last bullet here is, otherwise DCA really didn't publish much in the way of guidance or MRDs this year, beyond a few related to COVID and pandemic relief funds, which Ryan will cover later. So generally a pretty quiet year from a DCA guidance perspective. As we'll go through, there's a decent amount of interesting case law that did come out this year. So if you want to go to the next slide, before we go to cases, there was one proposed rule that was issued in the fall. It's a DFARS proposed rule dealing with IR&D costs for contractors. And this came about from a recent NDAA change, and it's another regulatory update or change in the long and winding road of DoD trying to get a handle on contractors' IR&D spend, and is it for appropriate purposes? Is DoD getting a benefit? The latest update here would shift the requirement from the government for reviewing IR&D projects to determine whether they are of interest to DoD, and shift that to a CEO determination at the company that those projects will benefit DoD capabilities or technology in some way. There was a good amount of industry comments on this rule, specifically around what that certification process is. Does that seem right? Will there need to be tweaks to that? And then the second half of the rule requires an additional report potentially from government contractors in addition to their current incurred cost proposal that they're filing. This submission would be required on a government fiscal year basis and would require them to show the details of their IR&D and B&P spend through a website or access. So again, there was a good amount of comment from industry in terms of challenges that there would be for implementing this. And so we'll see where DoD and the DAR Council comes out on this one. So next on the agenda is the first case that we're going to talk about. And this one came in just under the wire at the end of December, and it's cellular materials, deals with the issue of incurred costs, near and dear to accountants' hearts. So I'll turn it over to Paul for
Sure, thanks. I'm sorry if I was making some faces. My screen suddenly went black. And we're pretty much up on the time for this section, but I'll just comment. I wanted to comment one thing about the IR&D. I agree with Joe about the winding road issue, but what's perplexing to me is how the government can put an element of allowability determination in the hands of the contractor, because right now in the DFARS, whether or not there's utility for the government is, from the government's perspective, an element of whether it's allowable. And so to have that determination be based on the company just doesn't make a lot of sense. But let me move us along quickly because we're getting, it's already 20 past.
Yeah, well, I can go quickly on defective pricing later. So
okay, so just on the cellular materials case that we have here is the most recent case. There hasn't been a lot of case law in accounting cost and pricing this past year. This one, it's dated from December, but it only just came out published, I think a week ago or a week and a half ago. And here, this involved a question costs on the ICS regarding consultant costs. And ultimately, it came down to the question of a determination of language that's critical under the allowable cost and payments clause about like what is actual cost experience. And it's basically, when is a cost incurred? And under these circumstances, the only support that the contractor had was some promissory notes indicating that payment would be due within 5 days of demand. So first of all, it was dependent upon the consultant demanding the payment. Second of all, 9 years had passed and the consultant never demanded payment. So the board, it'll be an interesting read if you take a look at it, because the board traverses a lot of the Federal Circuit case law on this subject matter, basically concludes that it's very fact specific, but that the cases collectively show that a future expense must be more than merely likely or probable to be an incurred cost. And in this case, because the consultant had not demanded payment for 9 years, the board held that the costs are not incurred costs, but at best described as forecasted costs. So it's one of those peculiar cases that touches on the space, not an allowability determination, not a CAS determination, but in that sense, but dealing with supported documents.
and
Go ahead.
I'll just, if you were going to move on, I'll just comment now. But so I've been in so many conversations with contractors where the comment is made, we haven't paid that yet. How is it incurred? And as all the panelists know, you can incur a liability. But in this instance, it was determined that there wasn't a liability by the court. And I'll just comment, there's GAP, generally accepted accounting principles. There's that kind of guidance related to the issues here. So there's a lot of overlap interface between government contract cost accounting and generally accepted accounting principles.
Yeah, and the board didn't go down that path. And I think in large part because this was a case where the contractor CEO represented the company himself. And so that's another one of these challenging issues with cases. I mean, as the lawyer on the panel, I don't want to be pushing, use your lawyer, but we get a lot of wacky case law when companies just try to, handle these appeals themselves. And sometimes if it's a smaller organization, we've ended up with really unhelpful case law. So anyway, why don't we move to the next one?
As a non-lawyer on the panel, I'll say use your lawyer. Okay.
So last year there was an L3 Technologies Incorporated case also out of the ASBCA. This one is interesting because it's an example of what contractors go through all the time. So L3 Technologies apparently almost every year was having a dispute with the government regarding the sampling, the statistical sampling. And then they'd end up getting a contracting officer's final decision, sustaining the DCAA, and then, they'd go through some hubbubaloo. In this case, they appealed to the board, and ultimately the contracting officer withdrew the final decision, and then the government moved to dismiss the case because it was moot, basically saying, well, we're no longer disputing this. L3 actually resisted the motion to dismiss, and it was driven by the fact that they needed to finally get some resolution to an issue that DCAA kept bringing up year after year after year. And so that's what's important about this case. Now, in the end, the board went on a procedural tact and said, well, procedurally, we can't continue with this case because it technically is moot because there's no disputed issue. There was a dissenting opinion on that. But this was a case where, and in the dissent, the judge Clark said, you need to be able to get finality on this. And it was clear from the facts that this was coming up year after year. So it's exemplary of what contractors deal with. And so that's why we've got this one here.
Yeah, I just think it's a fascinating case. That's the only comment I'll make. Yeah, it's very interesting.
So the Banham case, if we go to the next slide, this one is interesting just for one particular element. This is out of the the Court of Federal Claims. And there was a Bureau of Prisons contract. There was a bid protest that happened. As a consequence of that, Banham's contract gets terminated. They submit a settlement proposal, and there's a bunch of costs that end up getting challenged. They appeal to the court. But in particular, it's just one issue that I thought was interesting here. So they challenged the proprietary costs incurred for the contract when it was terminated for convenience. And this goes to the question of evidence. The only evidence that Banham provided to support its proprietary costs was a spreadsheet based on their general ledger. And the Court of Federal Claims held that that spreadsheet was insufficient because there were no pay stubs or payment documentation to support the entries for labor and subcontractor costs. And we bring this case up here because the idea of adequate documentation and support comes up all the time. Typically, what the government and DCAA says is, they may just disallow an entire raft of costs, citing not a cost principle, but the provision in the general section of the cost principles dealing with adequate documentation. And here, that's why this is an important case to consider, because the court gave, judgment should apply. There is other case law that says that auditors should be applying some judgment. Here, the court felt that a spreadsheet was just insufficient because it wasn't enough data. I'm sorry, I was just looking to see that we had some questions here. And why don't we move on to the next? So LAX Electronics, also Court of Federal Claims from last year. This one, I think, is just interesting. It's a bid protest case. There has nothing to do with our world technically. But in this case, it involved a DLA contract, and the protester was arguing that the failure to follow a DoD manual was a basis for protest and challenging. And the court held that the DCMA manual was not binding law because it was an informal guidance that had not been promulgated into regulation and therefore could not form the basis of a protest. So why do I raise this? I raise this because we frequently, on the contractor side of the house at least, will cite to the DCAM, DCAA's guidance, when it comes to commercial items, we cite to the DCMA's guidance. There's a whole host of other things that are guidance documents. Recall that a section of the FAR that was put through regulatory procedures was moved to the PGI, and the DFARs rather, into the PGI. So suddenly I think to myself, gosh, could this case have ramifications? You know, it's this like discrete bid protest case, but could this have ramifications in other contexts like the ones that we face all the time? So something to keep your eyes out on there.
Yeah, I agree totally. And this is one where I often in expert reports cite to those documents that Paul mentioned to provide the trier of fact with context of the environment that we're in. Even if I don't agree with the DCAA's position on something, it provides a lot of context to us in the industry as to how the government views certain costs and how they should be treated.
So why don't we move on then into the next section on allowability. We've got a lot of content in here. If you can move on to the next page, please. So the Raytheon case, again, sort of like the CMI case we talked about in the beginning, actually came out, I think, right around the holidays of the prior year, but the decision didn't come out until the beginning of 21. So I don't think we looked at our slides and we didn't talk about it last year, so we're talking about it this year. This one is a long decision. It dealt with a whole range of types of costs. It's interesting and helpful. It's not just on allowability, but also on some on expressly unallowable costs. You'll note from the point here in June of last year, the government filed a motion for reconsideration on some of the issues on which it lost. And the board on a senior deciding group. So for those of you who are not familiar, it's very unusual. So the ASBCA on cases that it considers to be critical and significant will allow a case to be referred to what's referred to as the senior deciding group. There's 5 judges instead of just 3. And so the reconsideration was referred to them, and basically the entire 5-judge panel concluded that the government was just attempting to relitigate, and it wasn't allowed to do that on reconsideration. It had to show a different standard. So the case stands as it stands. Why don't we start flipping through the types of costs here? So if we can go to the next slide, please. So government relations, in-house lobbyists, like a lot of contractors have, they would record their time, but outside of business hours, not recorded. They removed unallowable business expenses that were recorded during business hours. DCMA, as it does, instead of parsing things, questioned 100% of the costs. They felt that the hours worked outside, and the non-lobbyist administrative staff costs led to an incorrect calculation, so they disallowed the total. On top of that, they assessed a penalty for expressly unallowable costs, lobbying costs. The board held that the government failed to meet its burden of proof to demonstrate the costs were expressly unallowable. They said ultimately that DCAA did say that the lobbyists kept their time accurately, and Raytheon's strategy for doing this had been adopted before the audit. So they were aware of all of this. Ultimately, the board concluded these costs were not unallowable, and therefore you can't get to the separate question of whether a cost is expressly unallowable. I will just say we're going to have this expressly unallowable come up a lot in this discussion. Unallowable is you just look at the cost principles, and based on the determination of the cost principles, is it unallowable. Expressly unallowable means that it has to be specifically named and stated to be unallowable. The type of cost has to be specifically named and stated as unallowable under the cost principle. So it's something that's more unassailable in a sense, as opposed to something that requires analysis or an open question. If there's any reasonable basis to determine that there could be a dispute about it, then it can't be expressly unallowable. But if it is expressly unallowable, then you get a penalty. So that was not determined to be. Let's move on to the next one. Development costs. So M&A expense. And Raytheon had a practice that was very similar to what a lot of contractors do. They had their own people that worked on strategic business activities and divestitures. Before a decision to make an offer or a go to market, the employees would record their time as allowable. Under 27 is the organization cost principle. After the decision to make an offer or go to market, the employees would record their time as unallowable. And so they put that in the economic cost principle. So they had created pretty much a bright line test. And I know that this is something that DCAA it's been like a thorn in its side, because it looks at certain language in the organization cost principle and believes that it's broader. But a lot of contractors follow the same practice of, okay, when have we made a decision? That's going to be our bright line. And on one side, it's allowable, the other side, it's unallowable. And basically, that's the position that DCMA took here. They also challenged the timekeeping practices that seems to be endemic in this case. And the board found that Raytheon's practices were reasonable interpretation of the regulations. They cited some of the prior case law. And they also said, hey, DCMA, you didn't demonstrate that the timekeeping practices were deficient. So the big point here is that bright line test was proven to be acceptable by the board. Next up, engineering, labor, overhead, patent costs. There were a couple of patent issues. And gentlemen, by the way, I know I'm trying to move us along here, but feel free to just jump in when you feel like you want to say something. Engineering, labor, overhead, patent costs. So again, a process similar to what we've just talked about, but now we're talking about patents. So they had a process for reviewing potentially patentable inventions and determining whether or not to pursue them. So they included the costs for administrative process and its allowable costs up to the point Raytheon decided to pursue the patent. So very similar to what their practice was regarding M&A. After that point, they designate the cost as unallowable. So another one of these kind of bright line approaches. But TCMA's view was that all of the costs relating to patent assessment process were unallowable under the -30, which is the patent cost principle, regardless of costs were required by the contract with government, which is one of the provisions. I won't recite the whole cost principle, but that's an element of determination of allowability. The board here found that both of the interpretations were unreasonable and came to a different conclusion. They said that any costs related to patent are patent costs, so you got to treat them under the patent cost principle. Patent costs required by the contract are allowable, so that was pretty straightforward on that. All other patent costs are unallowable. And if no patent ever results from an administrative review, the costs are then allowable. But then in that sense, what the board is basically saying is they kind of like fall out of patent costs because you've decided not to pursue that. So, kind of like this different 4 elements of what one needs to analyze when looking at their patent expense. But especially contractors who do a lot of engineering, there's some contractors where patent costs are not going to be meaningful, but there's plenty of you out there that this will be. Sorry, go ahead. Yeah, Joe.
Paul, I think the other lesson learned from the first 3 instances here, Raytheon had developed a good set of policies, controls, and processes across all of these areas. They were consistent in what they were doing. They informed their employees of what they needed to be doing and had controls to make sure that those were in place. And especially in the first 2, that definitely helped, build the case and have the documentation and well-defined policy. So I think that's a good lesson learned for other contractors, have developed policies and procedures in these areas. Tell your employees what they are, make sure that they're following them, because that creates a good audit trail, number 1, and may potentially be useful if it ever comes to needing an attorney too.
Sorry, I am just noticing that people who know me are emailing me separately through our emails with questions as well as through the Q&A. So I'm looking into
Stick to the presentation, Paul.
Yeah, man, we'll get to your questions if we have time at the end. So let's move on to the next slide here, please. So we are again talking about patent costs, but in a different sense in patent legal expense. There's a need to use outside counsel for patent applications. And Raytheon pooled these costs with the rest of their outside counsel legal costs and treated them as indirect. If the outside patent costs were incurred for once again, FAR 30 being the patent cost principle subject invention as part of a contract, they'd include the cost with its allowable costs. Otherwise, they'd include it in their unallowable base. DCMA objected to the practice, argued Raytheon should have charged the costs as direct costs to the particular contract. Again, board decided, you'll find in almost every single one of these cases, and for the point that Joe very properly raised, the board sided with Raytheon. They upheld Raytheon's practices of treating the costs as allowable and allocable indirect costs in this instance. And again, it's the point Joe made. Practices, procedures, is it consistent with the regulation? That's all in place, then the costs are going to be allowable. Why don't we move on to the next one? They also dealt with airfare, another one of everybody's favorite subjects. So if IR&D is one of the cost principles that has gone through all kinds of manipulation, then I don't know what we can say about the airfare cost principle, because that thing has been changed so many times. It still is confusing to contractors, and what's incorporated, what isn't, the references to internal agency guidelines, so forth. Oh, I see a daily attendance poll has popped up.
Right. And I'll just take this opportunity just how does a government auditor determine that airfare cost is fair and reasonable? It's all trying to get at that, but just airfare cost can change a lot. What is the best price in a particular market? That's why this has changed so much. I think the panelists would agree.
So I am wondering if we need to wait here for a moment for this poll question to be done.
I don't think so. I think
right, let's move on then.
Yeah, and Paul, the only other thing I'll say that's interesting in this case, if you are interested in about why some of the changes to the regulation came about, this case and some of the background and details, and it goes through the long audit history between Raytheon and DCAA. It's a fascinating read for how DCAA pushed what they wanted to get changed in regulation, which I know Paul covers some of this, but again, it's really fascinating from a cost and pricing perspective.
Yeah, and I think it depends on what judge you get on the cases, because some of them feel like, it's twofold. It's one is who are the lawyers on the case, because all of that's going to show up in the briefing. And the other thing is who's the judge, and are they going to go through and do the full analysis? Because one really needs to look at the administrative history or sometimes legislative history, because the reason why a lot of these cost principles are there is because there was a statute from Congress that said something that needed to be implemented. And you need to understand that to understand the regulations. But here, the change of the regulation was important to the case, because one of the other precepts about the cost principles is that it's the regulations that are in existence at the time that the contract gets executed that are applicable to the contract. So I always say to clients, when was this contract? Let's go back and look at the cost principles that existed at that time, because that's what governs, not what's today. And what frequently ends up happening is the auditor flips open the current version of the FAR and says, oh, here's the latest version.
Right.
Let's just look at that.
Well, and you can often do that. Some areas are static and don't change hardly at all from year to year, but the airfare cost principle that started this.
Well, and you never know. I mean, you never know. And one of the other things is all of us on, in all of these aspects of government contracts, whether you're working for the company or a consultant, whatever. We've been doing this for so long that everybody thinks, oh, I know what it is, it's X. You always got to go back and double check, because then all of a sudden it's like, oh, I forgot about there was this little standard in there or something.
Well,
So
and it's
anyway,
and the past versions are available online. You can go search the past. I mean, there was a time when that was figuring out what the past version said was a real problem. Today,
well,
you can find it.
when I was an associate in the 90s, I remember having to go through the facts and go find the paper one that led you all the way back to
or somebody that's got a bookshelf with every FAR from 1980 forward, and you go looking. Yeah. Anyway, you don't have to do that now.
Anyhow, let's move on here. And the point is that it was amended after they entered into the contract. And so, oh, no, I'm sorry, I didn't move on the slide. I'm trying to move on to the subject. We haven't even talked about it yet.
That was not a hint. That was not a hint.
So despite the amendment taking force after the contract, this had to do with about allowing airfare at the lowest rate available to the contractor. DCMA just allowed the cost in excess of the lower rate available to Raytheon because it had subsequently been changed. The other issue was that the cost principle allowed for higher airfare rates if the lowest airfare rule would result in unnecessary circuitous routes. So any request for a higher airfare would have to be supported by documentation, and Raytheon had a policy, once again, that's a point that Joe raised, for these situations, and DCMA disputed that and said, hey, your criteria were unreasonable. But the board said, wait a minute, you're applying the wrong version as to the one element, and then said that Raytheon's policy was reasonable. It specifically was in the section dealing with physical or medical needs of a traveler. So, and you can go back and look at the details and the facts to get a sense of that if you want to go and revisit your own policies for that guidance. Now we can move on to the next slide.
And just the last point, Paul, the court did say it was reasonable for Raytheon to use JTR and FTR from a reasonableness standpoint to help set their policy too. So good section for contractors to look at when they're setting their travel policies for their employees.
So then we're going to get into recruiting travel costs. And Raytheon reimbursed several prospective employees for travel expense during the recruiting process. Again, supporting documentation. Once again, this is another thematic thing here. Said that you didn't have supporting documentation that the individuals had been interviewed. They contended that the lack of supporting evidence demonstrated that the individuals that were being reimbursed for were actually guests of other possible recruits. Now here, Raytheon voluntarily rescinded about half of the costs at issue. And for the remainder of the cost, the board agreed that with Raytheon that the FAR did not require the contractor to produce evidence signed by potential recruits in order to recover the recruitment costs. So, it's this level of extreme detail that the government might find acceptable. I think, something with a recruit saying, yes, I was formally interviewed by Raytheon and therefore my costs are, that's going a little bit over the top, I think. But it's consistent with this whole inquiry about what's adequate documentation.
I get it. It is a little crazy. If I was a government regulator in a heavily regulated industry like this, I would say, yeah, if they kind of take a pessimistic attitude. If it's not documented, it didn't happen. But then the level of documentation gets absurd. The level of documentation they ask for at times just gets absurd, in my opinion.
Why don't we move on to the next one, which is another one of my favorite subjects. So here we're dealing with bonus, incentive, and restricted stock costs. And God almighty, this is a pet peeve of the government. I actually litigated a case for Raytheon on this subject, dealing with expressly unallowable costs on these subject areas with bonus, incentive, comp on these same cost principles. They're doing 22, 27, and 47. So that's the organization, lobbying, and legal fees. And, in the case I had, gosh, it must be, I don't know, I want to say like 2015, 2016, somewhere around there. They were trying to say that bonus and incentive compensation cost was expressly unallowable, tied to the cost of one of these cost principles, and the board just disagreed. Here, they're bringing the argument one more time, and they're saying that where the costs are unallowable, that the bonus costs are unallowable as well. Each one, the problem with these cost principles is it has some language in it about associated or related or something like that, right? And again, my problem with that is that's too nebulous when the standard for expressly unallowable is that it's specifically named, the type of cost is specifically named and stated to be unallowable. And that's the analysis that the board did in the prior case several years ago. Here, the board didn't have to get that far because they found that the underlying costs weren't even unallowable. And so they didn't have to get to the question of whether or not something was like, associated and then also became expressly unallowable. So it's not as helpful in terms of giving us anything meaningful other than say that the government is really persistent on this. Let's go to the next one. Souvenir or reminder item costs. So here's one where you can get a little bit tripped up about which cost principle should govern. Keep in mind that in the front end of the cost principles, there's guidance that says, well, one or more cost principles might be applicable. You have to look at the one that's most appropriate. So here, Raytheon distributed some items to potential recruits as an encouragement for them to apply online. They included the costs with the recruiting costs and charged them to the government. DCMA disallowed them on the grounds that they were promotion costs instead of recruitment costs. And if you look at -1, which is the advertising and public relations cost principle, there's a little laundry list in one of the subsections of that cost principle that talks about certain specific details like mementos and souvenirs that are allowable. And the board sided with DCMA in this instance and held that the mementos weren't allowable promotion costs. Probably not as controversial, but goes back to this issue of a contractor needing to figure out like what type of cost is this really? And I think we have, believe it or not, killed off the Raytheon case. So if we could move on to the next slide.
Well, and just not to let you get away with it that quickly. So can we expect the DCAM to be updated, the DCAA's contract audit manual or the guidance to be updated to reflect this? I think I know the answer, but somebody should say how the DCA will typically treat this sort of thing.
Well, I would say in those instances where they lost, probably not. Because if they feel like they may find another case to have the fight over, they're not going to start to amend the DCAM to say, okay, this is what you're supposed to do. On the other hand, they do need to be aware of the cases, and because if they keep coming back and saying, something's unallowable for a reason. But for example, the bonus and incentive compensation one, despite the prior case, they're still going to keep coming back. This case is not going to stop them from doing it because it wasn't decided really on a substantive basis. The Ology Bioservices case.
Paul, before you move on real quick, before you kill the Raytheon case, there was one question. It says and it's related to the patent question. Your last bullet states, if no patent ever results from an administrative review, the costs are unallowable. Does this mean no patent results during the time covered by the contract?
So let me go back to, so what they said is if no patent ever results from an administrative review, the costs are allowable, not unallowable. So I think what the board basically is concluding here is you have to go through the process of doing this potential viability and whether you're going to pursue something. And then and if you do, then you're going down the path because it becomes a patent expense. And so what the board was saying here is if it doesn't go anywhere, then, does that mean that it's really patent or not? And you're not going down the rest of that path where we have to make this decision. So we're going to just conclude that it's allowable. But hopefully that helps enlighten a little bit. But let's turn back.
Yeah, good. Yeah, good answer.
Yeah, we'll turn back to ology because we had, it's important. Raytheon was important because it dealt with a lot of subject matter. I have to say the remaining cases, I think there's like snippets of things that are really interesting and helpful. The ology case, this was an instance where this involved the cap on executive compensation. And this is something that was a little bit specific, but is problematic with the way that the government's been dealing with the caps that goes on from year to year. So what happens is technically the government is supposed to issue the new cap, and they're supposed to send out a regulation with the new cap, and they have historically been slow about that. And so there have been some years, including the fiscal years that were included in this case, where it was a couple of years later before the actual cap was put in place. Now, a lot of contractors, you can do the math and figure this is what the cap should be or probably ought to be, but it's technically not right. So here the CO determined that ology had exceeded the cap for executive compensation in its FY13 indirect cost rate proposal, but the agency hadn't published the FY13 cap until 2016. So basically, it's like, well, how am I supposed to submit my ICS in a timely manner using an appropriate cap if you're not going to publish it until 3 years after it's due? So the board held that their FY13 executive compensation costs were not expressly unallowable at the time it certified its final indirect cost rate proposal because the FY12 cap was no longer applicable. They used the FY12 cap because that was all that was around. And so what happened here is the government says, well, you're over the cap, that's expressly unallowable, and that's the position that they've taken. So here the board said you can't. So again, it's the distinction, was it unallowable versus expressly unallowable? You couldn't impose penalties or claim that it was expressly unallowable when you didn't even have the cap there. Why don't we move on to the next one, please? So there were a couple of Northrop Grumman cases that came out in the past year, but the panel collectively decided that this one was the more interesting of the two. So here there was a final decision, and this is sort of like the Raytheon case dealing with bonus and incentive compensation, where there was a contracting officer's final decision alleging that pension costs were unallowable as, quote, directly associated with unallowable compensation. And they also challenged the reasonableness under FAR. The 201-3 is just the general standard for reasonableness. But they raised reasonableness for the first time in a motion at the board. It was never part of the contracting officer's final decision. So what this case is about is really more procedural. It doesn't go to the heart of the merits on the question about whether or not the pension was directly associated and somehow unallowable. It goes more to the fact of, is the government allowed to, like, later on bring up some whole new reason why your cost is unallowable? Because they didn't say it was unallowable because it was unreasonable. They said it was unallowable because it was directly associated. And the board, unfortunately, concluded that the government could add this reasonableness standard because the board concluded, first of all, that reasonableness is just a basic factor in determining allowability, and fundamentally the question of allowability was at issue. And then the facts to determine whether or not something was reasonable versus this directly associated issue were not really materially different. So they decided on, you may recall there was a DynCorp case dealing with severance and the compensation cap and the relatedness of issues. And that will also dealt with a question of reasonableness. So, so this case is about the ability of the government after the fact to bring in yet another basis to challenge the allowability of a contractor's cost. So if we move on to the next.
And the government's position there would be that if it's a fundamental part of determining allowability, if it's a basis that's not related to some fundamental, one of the 5 factors of determining allowability, if it's not one of those 5, maybe the contractor still has a.
I think, so what we can get out of this is, like, to your point, Greg, if they said, oh, it wasn't allocable as opposed to not being reasonable, and they hadn't alleged that in the final decision, the board would probably say, oh, we'll cite this ology case and there, you can bring it in. I'm sorry, the Northrop Grumman case, and you could bring it in. And then, but I think the fundamental point there was that as long as it's consistent with the material facts. The thing, though, is the case law tends not to be as generous when the contractor files a claim, because the process is a little bit different. Contractor files a claim to get a contracting officer's final decision from which it appeals to the board or the Court of Federal Claims.
Right.
If they don't raise, sometimes there's been some case law that says, well, if you don't raise certain issues for the contracting officer to decide, you can't bring it up. And, here they're being a little bit more lenient. Contracting officer's final decision is the government claim. And then because of the peculiarity of how the Contract Disputes Act works, then the contractor just has to go ahead and appeal it, and that's all you have to work with.
Interesting. No, that's an interesting dichotomy or difference.
Yeah, it's one of the this is yet another reason why you need to hire a government contract lawyer and not just any old lawyer, because all of these nuances about how the process works is not the same as in federal practice. So fortunately, I think we're right on the edge of the time that we had allotted.
Don't worry about the time. Triple canopy, though.
But that's what I was going to say. So we're on our last one, which is triple canopy, and I wasn't going to skip it over, Greg. I'm just.
I was afraid you were going to skip it. So.
I'm looking at the clock. So there was a case. This is a case involving Afghan after-imposed taxes, which was a big issue. It's probably almost a decade ago now, and everybody was like, "Oh, we're going to have to pay the taxes, not, or it affects the licenses." There's a big hullabaloo. There was, what did the SOFA say? There wasn't one. Blah blah blah. So Triple Canopy had gone to the Armed Services Board and because it had submitted a claim to recover the costs of the after-imposed taxes. And the case ended up getting resolved on the statute of limitations. And the board had said, sorry, Triple Canopy, but you didn't file your claim within 6 years of the of learning of the penalty. And so you're too late to be able to pursue the claim. The Federal Circuit reversed it, and I have to agree. I mean, the Armed Services Board decision, I think, was really wrong. So I'm glad that they went to the Federal Circuit and reversed it. And the Federal Circuit, now again, on statute of limitations, you have to it all relates to when your claim accrues, and it's when you knew or should have known of the basis of your claim, and then also an injury occurs. So there's those two elements. Either you have actual knowledge or implied knowledge, and then you have an injury. And so the Federal Circuit said, well, wait a minute, the contract includes the foreign taxes clause, which specifically says that a contractor has to take all reasonable action to obtain an exemption from any of the taxes. So when they were assessed with this, Triple Canopy went through the process of appealing through the Afghan system. And it wasn't until after they actually knew that, hey, we have to file taxes, that they went ahead, and that was within 6 years. And so the Federal Circuit said, because this requirement was a pre-claim procedural requirement, and there was a KBR case that they had decided a few years ago that was similarly situated, not involving Afghan taxes, but involving a pre-existing factor that KBR had to do before it could even file a claim. And here, Triple Canopy had sought an exemption. DOD even supported that exemption request. And so the Federal Circuit said that the claim did not accrue until Afghanistan issued its decision on Triple Canopy's appeal. That's the Triple Canopy case. It's great in terms of both a cost allowability type of issue and also in terms of statute of limitations. So what I'm going to do at this
well,
point,
and just if you were sorry if you were getting ready to move on, I would just regarding Afghan taxes, it's come to my attention, not related to this case, but just Afghan taxes. What is the amount owed to the Afghan taxing authority? It's sometimes in question because they might assess an amount, but then that's like the asking price and it gets negotiated. So what amount does the contractor put on its books as the liability for Afghan taxes? That's a little bit of a troublesome issue from a cost accounting practice, from a point of view of cost accounting.
Yeah, well, and to the injury, to the injury element, I would be more conservative and, file a claim once you know that you have to pay something.
Yeah.
You've gone through the process, even if that number is going to change. There's a question of whether or not you have a sum certain, which is a requirement, but I'd rather like get it in too soon and then be told, it's not right than to wait too late and then say, oh, now it's beyond.
Right. And I think the GAAP, the generally accepted accounting principle, the GAAP guidance on it is it's got to be estimable and probable. And then if it's estimable in a range, you pick the low end of the range. And Joe or Ryan can correct me if I'm wrong on that. But if that's the case, then that's a whole process the company has to go through to figure out what is owed and what they're going to record as a liability.
Well, Greg, since you're talking, I'm going to just let you continue because we're going to move on.
Okay. Thank you so much.
If we can move to the next slide.
Yeah, to the next slide and then to the next slide. Yeah, on the one you're on right now, TransDigm. So thank you, Paul and others. So this TransDigm saga continues. Let me just to help the audience get oriented or the context. So remember, a government buyer has to determine something to be fair and reasonable, the price to be fair and reasonable in order to place the purchase. And so if there's competition that they can rely on, there's different competing offerers, they can rely on the competition to determine that something is fair and reasonable. Sometimes there are sole source procurements. In other words, there is only one offerer of what the government needs to buy. Okay, if this sole source purchase is over the TINA threshold, over $2 million currently, then the government buyer can compel the seller to provide certified cost or pricing data. So lots of cost information and other information that will benefit the government buyer in assessing whether the amount is fair and reasonable. If it's sole source and under the TINA threshold, the government buyer doesn't have the ability to compel the seller to give it certified cost or pricing data. And that's the kind of the space that we're dealing with here with the TransDigm saga. And so I'm going to just kind of lay out a few things from this, the Department of Defense Inspector General audit report from December 2021. But they found that price analysis techniques, there's price analysis and cost analysis. Price analysis is largely comparing prices, not cost buildup, but prices to competing prices or historic prices or other price activity. They found that price analysis techniques were not effective for identifying excessive pricing in a sole source environment. And the IG auditors went in and they got from TransDigm information that TransDigm had not given the contracting officers when they were negotiating the sale of some of these parts. And they found excess profit levels that range from 2.8% to 3,850.6% after a 15% profit was applied. And so in other words, they defined 15% profit as well. They don't never call it fair and reasonable, but they said any profit amount over 15% is excessive, and they work through things based on that standard. And if we can go to the next slide. So there was this December 2021 report, and then there was the report was prompted by a request from the House Committee on Oversight and Reform, requested the DOD-IG to look at this TransDigm's pricing and TransDigm's kind of organization, if you will, for how they've structured their business. And that's how they structured the business is not as interesting for our purposes, but the pricing was. And so then so there was the December 2021 report. Then in January 2022, I think it was the 19th, there was a hearing where congressional oversight people could express their outrage. This was somewhat similar to an DOD-IG audit report and hearing that happened in 2019. And after the 2019 hearing, the TransDigm was asked to repay the government $16 million. I think there were, they alleged that TransDigm had overcharged, but they also, I believe, admitted throughout that there was no law that was broken. And so, but TransDigm did pay the Treasury $16 million. In the 2022, now the January 2022 House hearing at the House Committee on Oversight and Reform, they're encouraging TransDigm to pay the government $20.8 million. And I have heard of no allegation that TransDigm broke any law or regulation, but just that they made excessive profits. So my take on this is that this is going to kind of fuel a renewed focus on cost analysis versus price analysis and kind of the role of profit for government contractors. The DOD-IG said in their report, certified or uncertified cost data are the two most reliable sources of information, ... for conducting audits. And that bothers me. I think prices should be considered the most reliable sources of information, not costs. And I put up what is currently one of my favorite quotes here in the last bullet on this page. Culturally, we have evolved to a point where we'd rather pay $1 billion and 5% profit for a defense good than $500 million and 20% profit. And I think that's in certain respects where we are today. And I'm about to open this up for comments. Just let me just say let's go on to the next slide and let's just where we are now. So there's in response to all this, DOD has submitted 2 legislative proposals, one related to commercial item determinations, and the other is related to obtaining the necessary cost or pricing data. And then they want to modify existing statute to require submission of uncertified cost or pricing data when necessary. So right now, it's not a requirement. The contractor can say, the government can ask for uncertified cost or pricing data, and the contractor can decline that request, as TransDigm did it in most of the instances studied by the DOD-IG.
Yeah, so Greg, nothing unifies Congress like the thought of a contractor making excessive profit.
Yeah.
So I would expect that, the 2 proposals again are going to be in line to be included in the next NDAA. They weren't in this NDAA, number 1. But I agree with your point on, market-based pricing versus cost-based pricing. The IG report rejects market or value-based pricing at all, just focus on cost-based pricing, which maybe in this specific circumstance has some merit to it. You're dealing with a sole source, single source manufacturer of certain critical spare parts for, airplanes and defense systems. But it's not clear what, trade-off assessments were done between the price that was paid to TransDigm and versus other mission impacts as well. So it'll be interesting to see what comes about here, especially the second proposal that would require submission of uncertified cost data under the TINA threshold, which again, seems like the pendulum swings back from let's try to rely on commercial items, market-based pricing, get innovative companies to do work with the DoD to let's ask for cost data for everything.
Yeah, this is such an adulterated statute, and I think when you go back and think about what the policy reason for having this was to begin with, back in the I think TINA was from the early 60s, like 61 or something. And then it's been and they've just struggled and struggled and struggled with it, and instead of getting more clear, it gets less clear. And to the last point that Joe was raising on the, whether it's uncertified, I think one of the problems that contractors have is if they go into pricing a contract and they don't expect it to be subject to TINA, they don't necessarily have systems in place to pull what would then be, cost or pricing data, certified or otherwise. And so there's a challenge here between this consistent sense by the government that contractors can push buttons and produce documents, and whether it has to do with complying with TINA or cost allowability issues or anything else. They're like, oh, well, you have these systems, just do X. And it doesn't work that way. And until there's a appreciation for how the commercial world actually functions, it's like putting a square peg in a round hole, I think.
Yeah, I agree. Ryan, did you have any comment? I've got a follow up, but I wanted to hear if you had any.
I think it'd be interesting to hear more from you about the 15%. Why is 15% the magical reasonable number here in this analysis? Doesn't seem to be tied to the weighted average profit guidelines. I mean, so why is 15% a reasonable profit in this situation?
Okay, and so I've looked at that a fair amount, and I have not found anything regarding that. I mean, I think if you do a DFARS weighted guideline, you can get to a maximum of around 17%. I mean, there's one of the factors at the end that's that you can't. It's hard to say what the amount will be. It'll be different for different types of contracts, but no, I don't understand. Well, I think they did make a comment about
they did in the report, Greg. They say. The reason they use 15% is because 15% is the highest stated amount per the limitations, of certain other types of contracts.
Yeah, cost reimbursement. And I think it's in FAR 15.404-4 on profit. If there is a reference there, I think.
Yeah, and then TransDigm as well had provided a range of, other contractors may make between 8 and 22% profit. And one of the congresswomen in a public statement said, well, DoD IG just used the midpoint of that analysis. So everyone seems to settle on 15%, even if they're using different rationale to get there, even if that doesn't maybe make sense.
Yeah. Well, and getting back to Paul's point, I mean, I could see people saying, well, why doesn't TransDigm or why doesn't the company just give this data to the government? Why don't they just push the button and give it to them? And just make sure everyone's aware. I mean, a commercial company doesn't need to comply with FAR 31 in their accounting practices. Complying with FAR 31 in your accounting practices is an expensive and cumbersome process. So if you just give the government your cost data, they may well have the DCA audit it. The DCA audits its criteria that it uses for audits is FAR 31. So you're going to kind of necessarily have issues, as well as just the sweep or going through the definition of what is cost of pricing data and providing all that cost of pricing data to the government. Big sophisticated multinationals have lots of policies and procedures relating to their estimating practices to make sure that they do provide all the necessary cost of pricing data when asked. Well, a commercial entity would typically not have that.
You know, something else on that point is, what's the consequence? You know, what if you on this if you're requiring submission of uncertified cost of pricing data, you know, if you are obligated under TINA to provide certified cost of pricing data, there's a definition for what all of that is and everything, right? And then there's a ramification for it, which is the failure to do it. Was there a cost implication, so on, and the adjustment and penalties, so on and so forth. What about if there is then a requirement to provide uncertified cost of pricing data, quote, when necessary, and a contractor doesn't do it, or the auditors come in and say, oh, you provided some, but you didn't provide this, and that, you know, that's another question of like, so is there going to be some kind of consequence to that?
Yeah. And I'll just, so there's a question that I'm going to summarize. I'm not going to read the whole question, but it just says, is it fair to gloss over the uniqueness? I think there's allegation, maybe it's true, but in the DOD-IG report, that TransDigm's business practice was to find companies that offer these sole source spare parts, buy those companies, and then increase the prices, or at least maintain the prices, and that was part of their business model. And is that to me, I don't think the government, if the government is getting that far into regulating the supposed free market economy, we're way too far into the regulatory regime. In other words, you can't have a free market if you're trying to go into what a business practice that John Q. Public or someone might not like that business practice, but there's nothing wrong with that. There's nothing illegal about that business practice. Is my take on that.
I think it's fair to bring up, you know, are you complying with spirit of the law versus letter of the law? But you have TransDigm's situation where, you know, oversight agencies are going hard after their business model, profits they're making. At the same time, they're trying to send signals to other companies to get involved with DoD and sell to the federal government. And some of those companies may similarly not want to provide cost data. And it's a hard answer to say what's right, what's the right balance between market or value-based pricing and cost-based pricing. You know, as a taxpayer, I don't want to be getting ripped off either. But ultimately, what's the right value and what's the right regime? And should some of these proposals be more specifically targeted? I don't know. There's not an easy answer to a lot of it.
Yeah, this is going to be debated a lot over the next year. So this is not the last time that we have a chance to discuss this. So I was going to move on to the next subject. So if we can go on to the next slide, trends in defective pricing. There is significant audit activity, as when Joe was showing his slides was obvious there, and we commented on. There is a DCMA working group to evaluate defective pricing cases. It's not a very large working group, and I think its focus is on thorny or more complicated defective pricing issues, not run-of-the-mill, not just trying to deal with run-of-the-mill audits or resolve run-of-the-mill audits. It's more difficult ones, but they are, the DCAA and the DCMA are working together on that. I would just say in the current environment, it's good to train personnel and remind people of what is the definition of cost of pricing data, and then what are the elements of defective pricing. And I was just going to walk through those quickly on the next slide.
Yeah, before you do that, I will comment on your first bullet point that I have in the last 2 to 3 years seen a huge uptick on defective pricing audits. And, you know, it seems like, you know, I tend to do a lot of the CAS work, and that comes and goes, and allowability issues, but all of a sudden TINA is coming in like a cavalcade. And the other thing to be aware of, and we don't address this specifically in the slides, is, you know, the concern about how TINA frequently gets tied to the False Claims Act. So back to you, Greg.
Well, okay, but you just to focus on one thing you said a real uptick in defective pricing audits. And would you also say investigations and disputes and that sort of thing involving the various?
Well, I will say, yeah, both. So there have been more than one instance where the defective pricing and, we've gone, how the audits go. It's like you respond and then you wait for 8-9 months for the government to come back, right? And then, so some stuff has gone off into investigation land. Some stuff is, sitting around for lengthy periods of time. Some stuff has gotten resolved. But it's just, it's in my 34 years of practice, or almost 34 years, that I don't think I've seen this much TINA work.
Yeah. And so if we go on to the next slide, I'm just going to cover this quickly. This is the 5 elements to establish defective pricing in the DCAA's guidance, in a government audit agency's guidance. And so just to make sure that you're aware of that, it's not from necessarily from a case, although it may have come from a case initially. But item 1, that the information in question fits the definition of cost or pricing data, which is in FAR 2.101. 2, that accurate, complete, and current data existed and were reasonably available to the contractor before the agreement on price. 3, the accurate, complete, and current data were not submitted or disclosed, that the government individuals did not have actual knowledge of such data or its significance, that the government relied on the defective data, that the government's reliance caused an increase in the contract price. Those are all the things that you end up fighting about. So it's much more the story of the negotiation, the story of the RFP, the proposal, and the back and forth, the story of what happened there, than it is about cost data per se, in my experience.
You know what? Oh, I think one clarification on point 2, it's available as of the date of agreement on price, which is slightly different than what's written on the slide about before the date of agreement on price.
Thank you.
Which is the whole point of needing to do a sweep.
Yes. Thank you. So I was going to change anything else, any other comments about defective pricing? If not, I was going to change subjects and move on. And Ryan, I'm almost to you.
I think you have one more slide.
Yeah, I do. I'm just, this is just an issue that we're seeing that's affecting, that's still out there for kind of the non-DOD, NASA, and Coast Guard contractors. And so, before June of 19, it relates to the submission of certified cost or bracing data. And there were these 3 scenarios for exceptions. In other words, if you meet one of these scenarios, you don't have to submit certified cost or bracing data. You're defined to be there to be adequate price competition. So the 3 scenarios were 2 or more responsible offerers submit proposals. The second one, there's a reasonable expectation based on market research or other assessment that 2 or more responsible offerers would submit proposals. So there's a reasonable expectation. Or 3, price analysis determines the price is reasonable. Well, the second one, this reasonable expectation one, was eliminated for DOD, NASA, and Coast Guard. And that's, I'm just pointing that out. So for the rest of the government buyers, with maybe one exception that Paul may remember, I don't know, one other exception, the rest of the government buying community has all 3 of these. And this reasonable expectation point is difficult to establish. So a government buyer has to establish that that they paid a fair and reasonable price, and if they rely on adequate price competition because there was a reasonable expectation, how do they ascertain that? How do they document that? That's just that's all I was going to say, but the other panelists may have something to add on that.
Yeah, so I think the reason why it's important to bring this up, even though this change was for a couple of years ago, is because it's starting to have some implications. This goes back to the point about my, pressing the button thing. Contractors go in with an expectation that there's going to be more offerors. So they go about pricing and how their systems may call for the need or not the need to collect cost pricing data. Then it turns out that despite the fact that there were 2 or 3 other contractors who showed up at the initial meetings and so forth, that you were the only one who submitted a proposal, and it's a DoD, a non-civilian contract, and then all of a sudden you're expected to comply with TINA, and so it puts some of these contractors in a conundrum of, okay, now what do I do, because we thought that TINA wasn't going to apply. And our systems need to be revised to accommodate for circumstances where you go into preparing a proposal on the assumption that TINA applies, and then all of a sudden it doesn't. I think the prior standards were a little bit more manageable for contractors, and now they're proving not to be.
And to piggyback on what Paul's saying, that issue's come up in estimating system audits and reviews as well. How are contractors handling these situations? Do they have the right processes and workflows if it turns out they have to submit certified cost or pricing data for a given proposal when they weren't expecting it to? And then from a proposal universe, so when they're handing over an audit population to DCAA, are they kind of clearly identifying the different types of proposals so DCAA or others aren't confused about what they should be seeing from a documentation standpoint in a given proposal file as well? So I agree with Paul, there's challenges in implementing this at contractors to make sure that they're pulling together the right information or that it's available for any given proposal.
Yeah, and purchasing system, when the prime, a higher tier contractor is buying from lower tier contractors, and their purchasing policies and procedures mirror the FAR, which they many times do. So they are buyers as well. Anyway, if there's any other comments on this, gone. So Ryan, you want to talk about COVID?
Next slide, please. So we'll go quickly through an overview of the various relief or economic packages that have been available over the past 2 years. A nice mask there, Paul. And there's quite a few of them. They've changed over time over the past 2 years through various acts. But it's critical from a cost accounting perspective to understand each of those programs, which programs your company or your subcontractors have participated in, and then how do you consider those both from an incurred cost perspective, but then also forward pricing with regards to changes to the business model and using historical data. So some of the major areas that came through in the CARES Act in March of 2020 was Section 3610 with paid leave reimbursement. The Paycheck Protection Program, PPP, there was 2 rounds of that. It was ultimately administered by the SBA. The Employee Retention Credit, which provided employers credits associated with Social Security taxes, and then the payroll taxes deferral, which allowed the employers to defer the deposit of their share of the Social Security taxes. Next slide, please. With regards to Section 3610, it allows the contracting officer the discretion to reimburse the contractor for leave, including sick leave, to maintain the employees or the subcontractors in a ready state. So the ready state refers to the contractor's ability to mobilize and resume performance in a timely manner. And so I think it's critical to understand that you have to negotiate with the CO to be reimbursed these costs. Under Section 3610, you're allowed to be reimbursed for up to 40 hours per week if an employee cannot perform work at the job site due to closures or other restrictions, and they're unable to telework because of their job responsibilities. And it's not either you can't or you can work. There could be portions of an employee's time where they can effectively telework, and they should, and there could be some of their activities that have to be performed on site where they would be eligible for 3610. Under 3610, the employee doesn't have to drain their entire leave bank before the 3610 would kick in and cover their costs. It's also available to contracts performed outside of the United States as well as foreign contractors. So just something to keep in mind there. Under 3610, it's been extended multiple times. So it went from March 27, 2020, now through September of 2021. And contractors should be focused on the types of documentation that they should be maintaining to ensure allowability, whether that's treating the costs as direct project costs or potentially treating these as indirect and allocating them back and having some type of equitable methodology to do that. But you need to ensure that you're segregating those costs somehow in your cost accounting system. Also, it's important to understand from a 3610 perspective, there were many other programs that an employee may have been considered in when determining other credits the contractor received, and you wouldn't be able to double dip under 3610. So if you're using some costs for an individual for PPP forgiveness, they shouldn't be claimed here for allowability purposes under section 3610. Next slide. The Paycheck Protection Program was designed for small businesses to keep as many employees on the payroll as possible. There were 2 rounds of PPP. The first round was in 2020. The second round of PPP funding was in 21. And under that program, the loan could be forgiven if it was used for specific costs, primarily, again, for payroll costs. So 60% of all the costs had to be used for payroll related costs, but you could claim other costs as part of the forgiveness, whether it's interest, rent, utilities, or other eligible operating costs. From a credit perspective, we'll dive into this in more detail. How do you account for the credits? The credits, oftentimes, the forgiveness of that would be received in years subsequent to when the loan was received. And so there's potentially some conflicting guidance depending on where you're looking or potentially what's most equitable for a contractor under the PPP program. Okay, next slide. With regard to the PPP program, the Department of Justice has formed a task force. They are going after companies or individuals that are falsifying applications. So through that process, you would go to the local bank, you would fill out an application that would be reviewed and submitted to the SBA for review and approval. And if you falsified any information throughout the process, which many individuals did, you could be convicted of bank fraud. So fines up to $1 million or imprisonment up to 30 years. And the DOJ is actively pursuing individuals under the bank fraud statutes related to PPP. Next slide. Okay. In addition to PPP, employers were able to take advantage of the employee retention credits under section 2301. And this program allowed employers to obtain credits regarding the employer portion of Social Security, both in FY20 and FY 2021. In FY20, that credit could be up to $5,000 per employee. And in 21, the credit was increased up to $14,000 per employee. So significant for many employers. And that was extended through the IRC. So the IRC took the regulations out regarding the employee retention credits through December 31st, 2021. It's important here, again, to remember that when requesting these credits, we're not double counting or triple counting eligible costs, whether it be between the CARES Act, whether it be the PPP loan forgiveness or the Families First Coronavirus Response Act. All of these acts look at very similar costs in determining the credits available to contractors. And so in determining what's eligible, the organization from a cost accounting perspective needs to be diligent in analyzing each of the programs that they're participating in, ensuring there's no double counting there. Next slide. Section 2302 is regard to Social Security, where an employer could, again, defer deposit and payment of the employer's portion of Social Security taxes. Next.
With regards to the Families First Coronavirus Response Act, there's again a number of credits here available to employers, as well as leave for employees. So extending the amount of paid leave available to individuals, as well as leave associated with COVID-related illnesses. And then within Section 701 and 703, they provide additional credits to the employer associated with payroll taxes for the additional leave. Next slide. In the essence of time, let's go one more slide. So from an incurred cost consideration perspective, many organizations have received a significant amount of PPP funding, specifically potentially, some of the smaller subs working for the primes. And so you need to be cognizant of the forgiveness credits that they should be claiming, and then the year that the credits were provided in. So from a DCA perspective, there's guidance within MRD 20.PIC-006, which has been revised. And the DCA is saying that the contractor should claim the credits when the PPP loan is forgiven. That may make sense for many companies if their contract portfolios are consistent from year to year, the funding sources are consistent from year to year. But there could be instances with some contractors where that may not be an equitable distribution of the credits back to benefiting projects. And so I just wanted to open that up here for conversations amongst the panel. Are you seeing clients within that you're serving receiving these credits where this DCA guidance may not be the most appropriate treatment of the credits? And what types of methodologies are the clients taking to ensure that is an equitable distribution?
Yeah, so Ryan, we have seen some instances where the contract mix shifted significantly year over year. So maybe the year that they had a PPP loan and used the funds that focused more on firm fixed price type work, subsequent year where they received more cost reimbursement work and received the credit. So maybe in that instance, it doesn't necessarily make sense to follow, a cash-based basis for the forgiveness. So that's one kind of instance that we've seen. But Greg, I saw you take yourself off mute too.
Well, yeah, and mine is more related to so the House Small Business Committee had a hearing on this point in March of 2021. And there was significant misunderstanding, I think, but from the participants, and I testified at that, is why I'm aware of it. But there were significant misunderstanding of the DCAA's guidance by the participants. And I think it was just, these were contractors to state DOTs, Departments of Transportation, contractors. So there weren't, they not as steeped in the cost accounting practices as are the DoD contractors that follow these very closely. But they were doing like forecasting rates, just whatever this year is, it's going to be the same percentage going forward. And we all know that that's not, you need to look at what is the pool next year, what is the base next year. If there's a credit, what is the impact on the pool and the base in your forecast? You need to do a little more of a rigorous forecasting process. That was my only comment.
Yeah, and the Department of Transportation contractors that Greg is referring to, if they undergo an audit, those audits are typically conducted by third-party audit firms, and they follow AASHTO audit guidance for that. That guidance published around PPP loans says something that's a little different than the DCAA guidance in terms of how to handle the credits for allocation bases. So again, understanding what types of contracts and what audit they may be subject to is important, so you understand audit expectations as well for that. I think the DCAA MRD is pretty good. It lays out a lot of FAQs, a lot of examples. I may not agree with how they've laid out the examples to handle the credit as it relates to allocation bases. They're saying that the credit should be not considered from an allocation-based perspective, but DCA's position is at least clear. So I chalk that one up as good to understand what the audit guidance is and what the auditors are going to be saying.
And I concur that it's clear, but it's very technical. And so it's easy for people outside of our industry, if you will, to misunderstand it.
I agree with that.
So,
And
yeah.
you know, Ryan ran through the litany of the programs. Again, it's really important to understand what ones a company may have participated in, to Ryan's point, to make sure then that you're not double counting and handling all the credits in an appropriate manner. This will probably be the first year, I think, that we'll see more focus from an incurred cost submission perspective on it. So again, just make sure before submissions go in that everyone's pretty clear on what programs the company participated in, what types of credits or deferrals were related to that, and how that is reflected in the accounting records.
Next slide. From a 3610 perspective within incurred cost submissions, best practice again here, creating some type of charge code for the projects where 3610 was leveraged based upon negotiations with the CO. For some businesses, it may be appropriate to charge those costs in overhead or G&A pool and allocate them back to projects. But again, every organization is different, but great guidance here regarding 3610. Next slide. From a forward pricing perspective, a lot has changed within the industry over the past 2 years. The pandemic has forced people to telework. We've changed manufacturing processes for social distancing. We've reduced certain costs. We've increased costs in other areas. So from a forward pricing perspective, one of the big areas was to rely upon historical data to inform other budgeting forecasts. And that historical data over the past 2 years may not be representative of the business that exists today and the nature of the cost incurred. So when preparing your forward pricing rates, I think it's important to consider all of those things that have changed. Consider policies and procedures regarding leave and other benefits that may now be provided to employees. Ensure that those are allowable, they're formally documented. And that's all considered as part of your forward pricing rate considerations. But I think it's going to be interesting to see what happens and what's approved, because there is still so much uncertainty in forecasting those rates into the out years. So in the essence of time, we'll go to the next section here to close things out.
We don't need to cover CAS.
Okay.
Unfortunately, there's nothing on CAS to report. So back to you, Ryan.
So there's really no cases yet from a perspective of COVID. However, there is an interesting case if we go back to Ebola, which was, I think, a very unique situation, very isolated compared to the current pandemic we're in. And so, Paul, just let you highlight some of the key areas here in this case.
Yeah, I think I'll be super high there on this. It's just a case that
Paul is super high. The record reflects Paul is super high. Go ahead, Tom.
Thank you. High level on this. It was a CBCA case involving Ebola. Basically, the civilian board concluded that the contractor was not entitled to any recovery for the costs when it submitted a request for equitable adjustment. We've discussed these cases before in other arenas. But what's important about this is that Pernix appealed to the Federal Circuit, and the Federal Circuit just only issued a affirmance. There's no substantive decision, but they affirmed the decision from the civilian board. So this is actually now a Federal Circuit level decision, basically adopting it. So that's all I'll say for this, because I think we're right at 150. Or do we have until 2?
No, I think we're done, right, Alan?
Why don't we just flip through the next couple slides then? And to the point that was made here is no news is no news on the CAS board.
Right.
And actually, and there's not been much, there hasn't been anything in terms of like CAS cases or anything
Right.
noteworthy in the last year either.
Yeah, unless I get the hook, I'll just say that there is no industry rep on, the CAS board is 5 members. There's an industry rep. There is the industry rep position is vacant right now. They're evaluating 3 different people. Seems slow in the process of evaluating the people, but anyway, the industry rep position is vacant.
Yeah, so after a few years of a lot of activity, at least comparatively out of the CAS board, not very much. So there's a lot on their plate. Hopefully 2022, there'll be more to talk about.
Well, that's a good segue back to me to just say, we'll have to invite this panel back next year to talk about what's going on in CAS. And I'm confident that there's going to be a lot more in the cost pricing area next year because there's a lot more contracts. You've touched on so many of them. So the interaction, I think, was fantastic. It brought out some key points. Another good reason why people need to be paying attention to it, not just reading slides, because you miss so much of the dialogue and the nuances of these issues that you just can't put enough into words. So thank you, gentlemen, for that. Thank you to Joe and Greg, Paul, Ryan. Excellent job. Look forward to continuing the conversation with you about the cost pricing and audit issues. In addition, let me thank our panel, our event sponsors for their participation. We couldn't have put on this whole program without them. On this slide and the next slide is the panels for the session sponsors that we have. We thank them again for their support. So thanks again to the panel. Thanks again to our sponsors. We look forward to seeing you at the next session.